around the world have to deal with this. So I spent 18 years at the Department of Justice prosecuting federal cases throughout the country. And my focus really was on corporate liability, on companies. And I handled a lot of cases involving multinational companies. And I sat across the table from a lot of chief executive officers and general counsel who were in the position of trying to explain to me why they didn't think their company did anything wrong. And I'm pretty sure that's not where they wanted to be. I'm pretty sure they weren't happy to see me at that moment sitting across the table from a Department of Justice prosecutor. So what I want to do in this presentation is talk to you a little bit about my experience and the advice I'm giving companies now so that they can stay out of that situation of being across the table from the Department of Justice. And I'm going to speak even more broadly than that. I spent the last year working at the United States Embassy in Jakarta, Indonesia, also with the Department of Justice, but at the US Embassy, working with the Indonesian government officials on cyber law, talking about digital evidence, which is a whole separate conversation. We won't have that talk today, but digital evidence, talking about combating corruption. So in this program, we'll touch on a little bit of that. I want to talk about the increasing focus that companies, multinational companies, are having on cyber attacks and data breaches. I'll talk a little bit about the legal landscape. What are the laws saying? Because we know the laws are slow to catch up, but they're catching up. And we're at a really unique, I think, time right now. We're in a transition. And I'll talk about what I think that transition is and what it means for corporations. And we'll talk about the steps that some companies are taking, the companies that are thinking about this. What are you taking to minimize your risks? And I think it's important and hopefully useful for this audience that I'll share the ideas I'm talking to other companies about, because we want everyone to be able to do business together. I want multinational companies to work with other multinational companies. I want US companies to work with companies here in Taiwan. I want them to be able to work together. But they're not going to be able to work together if they're not on the same page about these cyber risks and data risks. And at the end, I'll tell you why not. Why more now than ever, companies won't work with other companies if they're not on the same page, if they don't have the same approach to cyber hygiene and worrying about how they store and secure their data. And if we have a little time, I want to do a little bonus here. I think we'll have time to get to this, to talk about what I see in the enforcement area and some other areas of law under the Trump administration. So here's a map, a visual depiction. I think it's often good to have it there in a photographic way of data breaches in recent history. This is just one map. There's probably many others, but this shows you data breaches, big ones, that companies have faced in the United States. It's a very colorful map because it's significant. This is not just, this does not include all the cyber attacks that have happened. You know, the cyber attacks is a much bigger category. It would be all colored. You couldn't even look at it if it was cyber attacks. These are only the cyber attacks that resulted in data breaches, of data being stolen. And here's some recent examples. Just this month, you can look every week and you'll see something new. Best Buy, Cisco, they just had data breaches. You may remember, this was a big deal in the United States, the company Target, huge US retailer, very popular store, huge number of employees. They had a data breach in 2013. Seems like a long time ago. 5 years ago, they had a data breach. It was one of the first really big ones that hit the US market. And companies didn't know really how to react at that time. That data breach was just settled. There were lawsuits filed. In fact, not just private lawsuits, which are class action lawsuits filed by consumers, because some 40 million consumers lost their credit card information as a result of this data breach. 40 million of them, that's huge. Those class action lawsuits from the consumers are still ongoing. But just recently, in 2017, Target settled the investigations that were conducted by the state's attorney generals. So a number of states in the US got together and took action against Target. So not only the individuals, but the states. That's important to know. Target just settled that almost 5 years later by paying $18.5 million. Sounds like a lot. I think that's low, and I think if it happened again today, that figure would be much larger. That was sort of the 2013 deal. It's only getting bigger, the amount of money that companies are going to be looked to pay as a result of data breaches. And this data breach that Target had back in 2013, you might be interested to know how that occurred. It occurred not because of Target per se, not because of this retailer, but because of a third-party company they were working with. We talked about the nice air conditioning in this room. Appreciate it. Very comfortable. Target wanted their stores to be comfortable too, and they hired a third-party contractor to run their air conditioning and heating systems. Simple enough. What is the risk there? You're running the air conditioning. How could that impact the data of your consumer credit card? Well, in order to keep the temperatures nice all the time, that third-party company was given the credentials to access the VPN of Target because they had to be able to monitor and adjust temperatures remotely. They didn't want to go into every Target store. They wanted to access the system. Let's get into your network to monitor your air conditioning. That's how the malware got into Target, from the third party. That should have been a wake-up call. It wasn't enough of a wake-up call because today, more than anything, it's those third parties, the people who you do business with, that are the risks. And that's what companies are focused on. Uber had a hack. This was a much more recent 2017 massive data breach. 57 million customers and drivers' information. Right as a result, the next day, class action lawsuits were filed in the United States against Uber and the attorney generals, the state authorities of multiple states started investigating. Not even just the states, but even on the county level, on the local level, LA, Los Angeles County started investigating Uber. Lots of people are telling companies through their actions, we're going to hold you accountable when there's a data breach. And the FTC also has an inquiry going on. But here's what the chief executive of Uber said. None of this should have happened, and I will not make excuses for it. None of this should have happened. That's a pretty bold statement. That's saying I'm taking responsibility for this data breach. Why do I think that's important? Because if a chief executive officer is taking responsibility for a data breach, that means that is a huge risk for them. If you're taking responsibility and ownership, that means you're responsible, which means you think it's a risk. So what do? You need to minimize that risk from now on. Reduce the risk. No justification for the cover-up that happened later, right? So it wasn't just a data breach, they didn't tell people about it. That's a simple one to answer. Never do that. As we say as prosecutors, John and I know as former federal prosecutors, we love to catch people for the cover-up that happens later. That's much easier to prove. It's the lying that happens later, right? That's never acceptable. That makes it easy for the government to come after you when you lie about it. So, connectivity and data collection is now everywhere. There's some 4 billion internet users. It's just getting bigger and bigger. 12 billion internet-connected devices worldwide. The average American has 4 of those. I think maybe, are you above average, John, Harvey? Above average? Got at least 4 internet-connected devices. And remember, we'll talk, that's pretty broad. It's not just your laptop and your phone. There's lots of other devices we all have now. And here's the scary part. The data is medical, financial, maybe your personal fitness, your health information. How about Facebook coming out with a Facebook Messenger for kids? Your children's information is out there. Your homes are connected. And of course, artificial intelligence, which we've been talking about a bunch today, is collecting all kinds of new data. Data we don't even tell it to collect, right? It's collecting data we might not even know what it has. In fact, there's no way we're going to know exactly what data it has. What does that say to me and what it should be saying, I think, to most companies? R-I-S-K, risk. The Internet of Things, everything is sharing information whether we tell it to or not. Here's one from 2017 from last year. Look at this nice little toy, how cute. Innocent, right? You're not worried about that, let's give it to all your children. Well, a lot of people did give it to their children. It was Wi-Fi and Bluetooth enabled pet. How cute. Squeeze its little paw. Can I squeeze your paw? Squeeze your paw and I record a message. And then that message goes to mom or dad or grandma who lives somewhere else. It's so nice, right? Well, you got it hacked. And that information was stolen. So nobody, were they thinking about that? Maybe not. They should be now, and every other company should be now. Fitbit. Who's got a Fitbit or some other similar device on their wrist? Very good. Nice. Well, we learned in 2017 that that Fitbit was going to be key evidence in a murder trial. This case is still ongoing. Wife is murdered. When the wife is murdered, you come and you talk to the husband, right? The spouse. Husband says, oh my gosh, someone broke into our house this morning, tied us up, killed my wife, and I'm lucky I escaped alive. Very lucky I escaped alive. When did it happen? Oh, it happened at 9 o'clock in the morning. I know it was 9 o'clock. You sure? I'm sure. 9 a.m. Well, let's take a look at the Fitbit that she was wearing on her wrist that showed that she was still up and walking around at 10 o'clock in the morning and later. So the story starts to fall apart because of the data. So in 2017 even, we started to realize, oh, this stuff is collecting data that's useful to all kinds of people, including prosecutors. Echo, the same thing. I think someone mentioned that earlier. What's it listening to? Of course, inevitably, the Echo is involved in a murder case. The prosecutors want to know, well, what did Echo hear about what was going on in the room? Is Echo listening? Well, what am I thinking as a lawyer, and what, or maybe some of you thinking, where's the liability? Where's the risk in all this data? The data's out there, but until 2017 and now certainly 2018, people weren't thinking about the risk. They just thought more data is better. But that was the last 10 years. It was collect data, collect data, collect data. And don't worry, we're still going to be collecting data in the future, but we're going to be thinking about the risks, or at least I think the people who are smart are going to be thinking about the risks. Because as companies start accepting responsibility for that risk, they're going to try to minimize it. I think the honeymoon is over with all this data collection being free. It has a cost. We have to pay for it. We have to pay to take security measures to protect that data and that information. So people are also waking up to that in the United States. The privacy concerns about that data. The government is waking up. The federal and state government, politicians are waking up. Mark Zuckerberg was just in front of the US Congress testifying last week about all the data they were collecting. The government in the United States is waking up. What's going on here? And Zuckerberg is apologizing. I'm sorry. I think what he's really thinking about is the risk. That's what he's really thinking about, and that's what other CEOs are thinking about, the risk involved. The risk of litigation, the risk of federal enforcement action, the risk of regulation, of new laws being passed that change the business model. Talked about the driverless cars. I had to mention it myself. Was Uber's driverless car crash avoidable? This happened just a month or so ago in the United States. One of the Uber's cars crashed. And here we already have people speculating after watching a dashboard video of the fatal collision. Some autonomous vehicle analysts say the car's sensors should have detected the pedestrian. So, right, this is exactly what we were just talking about. What data is being collected by all those sensors in the car? Lots of information that's going to be used for good and for potentially creating liability. So what's the legal and regulatory landscape? Well, it's evolving, but increasingly the state and local governments in the United States are acting on their own. The Federal Trade Commission is acting, federal government's acting, but here's the one I want to focus on for a minute. The Securities and Exchange Commission of the United States. Pretty important entity for all public companies. Hugely important. Well, they just came out with guidance in February on cybersecurity disclosures. And this guidance, I don't think enough people have focused on it. I want you to think about what this says. It's a long document. You can Google it, look it up. I recommend it to you. But here's a few key points from the Securities and Exchange Commission. Their guidance about cyber and the risks. They say as the company's exposure, that's what I've been talking about, the Internet of Things, we're all exposed now, and our reliance on network systems and the Internet has increased. So as this exposure increases, the risks have also increased. That's pretty simple, but the Securities and Exchange Commission is saying it. And they're saying much more than that. They say there's a duty to inform investors about any material cybersecurity risks. So companies have a duty to inform about the risks, as well as a duty to report the incidents. Two different things. So of course you know, as Uber learned, if you have an incident, you got to report it, but this is going much further. You have to warn about the risks so that consumers can say, hey, do I want to invest in this company if it's really risky? To me, that's a dramatic change. Not just reporting on the incidents, but reporting on the risk of an incident. And that's what it says, disclose the risks associated with cybersecurity, including the risks associated with acquisitions, mergers and acquisitions. Again, getting back to that theme that I hope is coming through, the third parties that companies are doing business with. If you're going to enter a joint venture, if you're going to buy products, if you're going to do business with a third party anywhere in the world, and that increases your cyber risk, is that reportable now under the Securities and Exchange Commission guidance? If you're a CEO, you're going to be thinking about that, and you're going to be much more cautious about who you do business with. I think that's really a big deal. So, under our state framework, almost every one of the states in the United States has a separate data breach notification law. We have to notify in different ways. The federal laws and the SEC guidance I just talked about. But here's another big one that I'm not going to get into too much today, another topic for a completely separate talk, is the General Data Protection Regulation that's going into effect here in days. And that's going to impact the world, in my opinion. It's not just going to be the EU. And of course, we're already seeing that. Facebook is basically promising to offer its users around the world the same privacy controls that it's now going to have in the EU. So Facebook really is having to change, and they're going to be changing worldwide. So that is a big impact. Let's look at the trends. Increasing private litigation for data breaches and cybersecurity risks. There's many more lawyers specializing in this now than there was in 2013 when Target had its data breach. Much more activity in this space. Fewer claims are being dismissed, increased regulation, higher standard of care, many more court decisions coming out. So that's the regulatory and legal framework is really dramatically changing. How about this? Another new law. This is a great topic because every day it's something new. Talk to me tomorrow, we'll have something new to talk about. The Cloud Act is a new United States law adopted just weeks ago related to this subject. And its CLOUD stands for Clarifying, lawful overseas use of data cloud. Does everybody remember the Microsoft litigation where the Department of Justice, where I worked, routinely every week we were going to internet service providers and we were saying, here's a search warrant, a judge, we went to the judge, we explained we have probable cause to believe that you have evidence, maybe it's emails, evidence of a potential crime, so give us the emails. And for years, Microsoft and Google and companies were giving this to the Department of Justice. And then they said, no, oh, sorry, my bad. We don't have that data. We stored it over in Ireland. So it's not here in the United States. We keep our data in this big data, all of our servers in Ireland, and we're not giving it to you because you don't have jurisdiction over it. That was what Microsoft said. So the Department of Justice and Microsoft were at a standoff, a big battle. It went all the way to the Supreme Court, and it was in the Supreme Court until today or yesterday. The Supreme Court just dismissed the case. Why? Because Congress, the U.S. Congress stepped in and passed a new law to address this very issue. And what Congress said was, U.S. companies, they are required now under this new U.S. law to respond to those search warrants and subpoenas from U.S. prosecutors, even if they store their data overseas. You can't hide it overseas. If the U.S. government has jurisdiction over you, bring it back from Ireland and give it to us. That's what it is under the law. If you control it, you got to give it up. So the Supreme Court saw this and said, oh, case dismissed. No more case of controversy. So it actually amended a different important law, the Stored Communications Act, which is what governs the ability of the Department of Justice and the U.S. government to get this kind of information. Now, the Cloud Act also did something else. It said that governments, the U.S. can enter into agreements with foreign governments. That will actually make it even easier for foreign law enforcement to get data from U.S. service providers. So right now, there's a bit of a challenge. I worked in Indonesia all of last year, and they would be frustrated if we want to get information from Google or Facebook. How do we do that? You guys can do it so easily in the U.S., but here's the American companies. How do we do it? Well, under the Cloud Act, there's a potential for making that easier. So law enforcement around the world are going to have an easier time gathering data from companies outside of their own jurisdiction. I think that's an important take-home point too, because enforcement efforts can then increase. If you can share information across borders, enforcement can increase. So what are companies doing to minimize the risk? Well, there's a lot of things, and we'll talk about a few of them. Here's some immediate steps that they're taking. They're looking at their data security programs. They're conducting cyber compliance reviews. They're updating their incident response plans related to cyber activities. So these are, we again spent a lot of time in each one of those. I want to jump to the bottom one for the purpose of this talk. Develop procedures for limiting third-party risks. Determine the level of risk that is appropriate for your company before you outsource any functions, before you share any data. And in fact, according to Target, before you even let people into your system to check on the air conditioning, you better know what risks are involved with that, particularly under the new SEC guidance. And we'll talk about due diligence. Develop a policy for before you enter into these relationships with anybody. So let's dig into that. Here's the biggest area of risks today in the cyber arena. It's third parties. Think about it, it's endless. Every company has to rely on other companies for something. Some companies rely on third parties for lots of stuff. They might outsource all of their human resources. Maybe they outsource their data, they outsource their credit cards. It just happens. But it's a big risk. So conduct the due diligence. Ask, if you're going to have a serious relationship with another company, whether it be internally or overseas, this is what U.S. companies are doing. This is the conversation and the talk I'm giving to executives in the United States. Ask if that company you want to do business with, have they conducted a cyber risk assessment, and will they share it with you? You say you're a good company, what are you doing about cyber? Have you conducted a risk assessment? Have you hired someone to come in and look at your systems? Share it with me, and then I can feel secure, just like you do due diligence in other areas. Do they have some kind of a certification? Have they been certified that their systems are operating up to a certain standard? What are the policies of the company you're doing business with? What will they do if they have a data breach? Will they do the right thing? Do you feel confident that your business partner will do the right thing if they have a data breach? Will they tell you? What if they lose your data? What are their responsibilities? Are they going to look out for themselves, or are they going to look out for all of you together? Do they have a dedicated chief information security officer? That might be a bit. Or have they not really thought of it? Are they still using their admin department, their IT department alone, to take care of all this information? Or have they designated an individual really focused on cybersecurity? That could be a really important indicator. Do they have a plan in place? Do they have a cybersecurity firm that they work with? Do they have outside counsel who are going to help them come in and respond when they have a data breach? If they don't, that's risky for you. Have they had any other cyber incidents? Are they required to disclose that to you? What if they had an incident a few years ago? Have they told you about it before you're going to do business with them? Here's a newspaper headline from March 5th of this year. Due diligence on cybersecurity becomes biggest factor in mergers and acquisitions, from the Wall Street Journal. So I'm not the only one saying this. Companies are realizing due diligence for cyber, big deal for all kinds of work. Also in your contracting, I'm going to go through this a little more quickly, but the idea here is not only are you going to do your due diligence, you're going to do your homework, make sure you feel comfortable. Okay, we can do business together. You're concerned with cybersecurity, I'm concerned with cybersecurity. Well, let's write it up in the contract now. Let's make sure we have provisions so we allocate risks appropriately. Are you going to do the right thing by contract? Do we even agree on the same terms? I'm sure there's lots of different meanings given to data breach. Well, we better define all those terms by contract. And so this is what we're advising clients and helping them with. What are the safeguards you have to have in place by contract? Do you have limitations on subcontracting? Who can that person then do business with, and what risk does it provide? Breach notification, indemnification, who's going to pay when there's a problem? How do you allocate risk? So you have to be thinking about all of this. This is just an example, whether it be in a new contract or an addendum to an existing contract. Maybe you've been in this long-term relationship, you're not going to want to mess that up, but you're about to renew it. It's probably time to include these new provisions in that renewal from those old business partners. You'll see this in all areas of the law, but people enter into these great deals and they're going on, everything's good. They'll go back and review and update their relationships with people because life is good. We're making money. Life is good until it's not. Right? So you got to think about this stuff. All right, look at this. We have time. We have time for bonus material. 3 minutes. Oh man. All right, we can do it. I just wanted to mention some of the, there's a lot going on in the news with trade sanctions and investments, foreign investments in the United States. CFIUS is a huge gatekeeper. This is another very recent article. It's the Committee on Foreign Investment in the United States, and it reviews when foreign investments are being made. And it's become, I'll jump ahead to this. Everybody familiar with Qualcomm and Broadcom, right? Well, that's an example of what CFIUS can do. The deal was blocked. President Trump jumped in and using CFIUS